Well, thank you, Lee and Stephen, for the opportunity to do a presentation and to answer questions. So, I have with me Penny Perrott. Penny is the manager of our regional and local planning department within my division, the planning division of the council, and she has led the whole unitary plan process at an officer level right from the start back in 2011, and of course reporting through to the council and particularly the Auckland Plan Committee, which was the one that made the decisions on the unitary plan. So she's got a 10-minute or so presentation, which hopefully will answer a lot of the questions that you've been asking, and hopefully set out clearly what the background to these mana whenua provisions is, and what the effect of them are, and so we'd certainly be happy to answer any questions you have on that. Can I just say that Councillor Dick Quacks is in the audience, so acknowledging him. And I just checked with him whether he wants to speak, and he said he doesn't need to because the chairman set out his views at the start of the meeting. So I'll hand over now to Penny Perrott.
Thank you, Roger. I do have a presentation which is largely based on the sites of significance and sites of value to mana whenua, but I just want to make a couple of comments before I get into that presentation. As has been said earlier today, the Proposed Auckland Unitary Plan is a new document for Auckland in terms of prior to the 1st of November 2010, before Auckland Council came into being, we had 14 Resource Management Act plans in effect across the wider Auckland region, which, as you would understand, led to a lot of confusion. If you were working or living or had land in different parts of Auckland, there were different sets of rules applied. So when Auckland Council came together, one of the first things it did was start working on the Auckland Plan, which set the long-term vision for Auckland, and then the Unitary Plan is just one of the tools that give effect to that long-term vision. It's not the only unitary plan in New Zealand. In fact, unitary plans have been in place in a number of councils in the South Island. So just to correct that comment made earlier, it isn't the first unitary plan. It's not also the first unitary plan or any RMA plan that has cultural impact assessment provisions in it. That is not a new thing. It is actually something that perhaps Auckland's legacy councils did not actually do a very good job on in terms of our obligations under the Resource Management Act. In fact, there are many other councils across New Zealand who have adopted CIA provisions for very many years. So in many respects, Auckland's catching up with other parts of the country. In developing the Unitary Plan, we're governed by the Resource Management Act, which requires us to consider certain things in our plan, and Section 6 of the RMA requires us to recognise and provide for a number of things of national importance. And one of those is the relationship of Māori and their culture and traditions with ancestral lands, water, sites, wahi tapu and other tonga. So it is actually something we're required to do in this unitary plan, and as I think has been mentioned in the past today, that comes from a central government legislation. We are in the middle of a statutory process at the moment. The unitary plan has gone through a notification process. Many of you are submitters. The hearings are just about to commence. That does mean, in terms of comments today from myself as an officer involved in that process, I do have to keep it at a very general level because we are working through a judicial process. The other thing I just wanted to touch on before I get into, I think I will start the presentation, just take you through some of the slides. Oh, okay, this thing. Okay, just a bit of a recap for those of you who might have come recently to the unitary plan process. It is a new process under legislation in terms of the way we've put together the unitary plan. Working with central government, they have introduced new legislation for this new unitary plan for Auckland. That encouraged us and required us to do a lot of upfront engagement with the community, quite different from the traditional unitary plan processes. So we put a draft unitary plan out in March last year. It wasn't polished, had mistakes in it, hadn't been completed, but the whole idea was to get feedback from the community about the things that were of concern to them, other issues in it. Now, we had 28,000 pieces of feedback on that draft plan. We attended as officers 250 public meetings, and we had over 45,000 hits on the website looking at that draft plan. In that draft plan, there were 61 sites of significance to mana whenua that were indicated as receiving protection, and there was a non-statutory cultural alert layer showing approximately 4,500 sites of value to mana whenua. Between that time and when the proposed Auckland Unitary Plan was notified in September, obviously officers went through 22 workshops with the elected representatives, both councillors and local boards, indicating the issues that had been raised by those feedbacks to the draft form. And amongst that feedback was a lot of concern from the mana whenua across Auckland that the non-statutory alert layer was not going to give them the level of protection to sites that were significant or important to them in terms of their values. So through that process, the decision in the proposed Auckland Unitary Plan made by the Auckland Plan Committee, not by officers but by the elected representatives, was that we would include a statutory layer of sites of value within the notified plan. It is only a notified plan. The purpose of having submissions and a hearings process is to improve and alter the plan in accordance with concerns expressed by a wide range of stakeholders and community in Auckland. And that process has been run by the Independent Hearings Panel. As you've heard, that panel was appointed not only by the Minister for the Environment, who was Amy Adams at that time, but also the Minister of Conservation, who was Nick Smith at that time. So both those two ministers were the ones that actually appointed the panel. It is led by a judge from the Environment Court, and I think that all be rather surprised to hear sort of comments today that they might be independent. They're definitely independent. They are monitored by the Ministry for the Environment, and they are responsible to the Minister. So while the Council provides them with staff to support them in managing the logistics of processing the hearings submissions and the pre-hearing mediation, they act in an independent state. Their role is to hear all the submissions. They have read the submissions. They were appointed back earlier this year, and so since the original submission period has finished, they've been going through all the 9,000 plus submissions that were received, and so that they will read all of those submissions. They will hear from people at hearings, but having read all the submissions will make recommendations on how the plan can be improved. Those recommendations then do come to the Council, and the Council can either adopt or reject the recommendations. What hasn't been made clear today is that if they reject the recommendations, it automatically goes to hearing at the Environment Court, and the Environment Court makes a decision, the final decision about whether those recommendations should have been rejected or not. Going particularly to sites and places of significance to mana whenua. So these are sites of significance. There's 61 of them in the proposed unitary plan. 46 of those sites were from previous district plans. So they were in Legacy Council district plans as protected as sites of significance. We've had 15 that have been identified by mana whenua and have been added as sites of significance. They're mostly on public or Māori land, and it's the strongest protection of the most significant sites. The mana whenua values associated with the sites are known and protected. And if we just put this into context in terms of European heritage that we protect in our unitary plan, we have over 500 scheduled heritage buildings, over 2,000 more houses are subject to historic character rules, and we have over 3,000 trees of significance that are their owners are also subject to rules about what they can do on their property. So in the scheme of things, the protection we've given to mana whenua or Māori sites of significance is very small compared to the value that we've placed on European heritage. And so that's the issue that mana whenua has asked us to address through this process. that as partners in the Treaty of Waitangi, equal respect of their heritage and values should be accorded through the Unitary Plan, as we have been doing for European heritage. In terms of if you have a site of significance on your property, it does mean that if you're undertaking new buildings, alterations or additions to buildings and earthworks, you are required to go for a resource consent and be assessed on that impact. Turning to sites and places of value to mana whenua, the draft unitary plan, as I talked about, had a non-statutory cultural heritage alert layer which had 4,500 sites. During the process in the final days of putting together the unitary plan, the Auckland Development Committee resolved that we should change that from a non-statutory site to a statutory site. The number of sites were reduced down to 3,600 because in looking at that, the original alert layer, there were a number of non-Māori sites on it. The sites have been identified using the Cultural Heritage Inventory. Now, that was an inventory put together by the former ARC, the Auckland Regional Council, and it was gleaned from data from the New Zealand Archaeological Association sites files. It is very much a precautionary approach. It is saying that in these areas were identified by our archaeologists as areas of Māori origin. We have had very little feedback from mana whenua that they disagree that those sites are of Māori origin, and it's a precautionary approach similar to the pre-1944 overlay that we have applied over large areas of the isthmus to protect pre-1944 buildings. We haven't surveyed those either. It's a precautionary approach. In terms of the sites and places of value to mana whenua, the rule is applied to earthworks. So if you're undertaking any activity that involves earthworks on or within 50 metres of a known site, then a resource consent is triggered, and you may be required to provide a cultural impact assessment. Now, we do recognise that there has been some confusion over the interpretation of those circles, and we are doing work at the moment, to really refine the information we have, but also we have made it very clear in information on our website how you actually use those 50-metre edges. Just going to the submissions, as I've said, we've received over 9,500 submissions. And around 440 of those were on sites and places of value to mana whenua. We had 344 on sites of significance to mana whenua. As I said, the independent hearings panel is going to be considering all submissions. There is a number of questions raised that, do you have to turn up to pre-hearing meetings? The purpose of pre-hearing meetings is to actually start understanding where do people sit in terms of submissions on various parts of the unitary plan. Because this is a different process, the Ministry for Environment and the Minister was very keen to try and make it more user-friendly for lay people. And in the normal process of hearing submissions on a resource management plan, you would turn up with a hearing. You'd probably have to sit for several hours listening to legal representatives from various submitters talking, reading through their evidence. The approach the panel's making at the moment is that's all going to be taken as read. They don't believe people should sit and listen to people read from the information that they've tabled. And so that's why they put a 10-minute slot so that everybody has a fair chance, rather than people who have hired lawyers who then in the past used to take up inordinate amounts of hearing time. They will read everything that you have tabled. They will read all of your submissions, and they are very, very concerned to ensure that happens. The only person who's required to turn up, or entity at every pre-hearing meeting, is the council. They also have pre-hearing mediation or conferencing of experts, and the purpose of that is actually to narrow down the issues and try and understand through the breadth of submissions on a particular issue, are there some common areas of interest? Can they actually refine down the issues of concern so that when we get to a hearing, those hearings do not cover areas that everybody's either in agreement with or disagreement. So the whole purpose is to try and reduce the hearing time going forward. It is quite complex at the moment because the first thing that they are doing submissions on is the regional policy statement, part of the unitary plan, which covers every issue. It sets an umbrella view on all of the issues in the unitary plan. So if you put a submission in on residential, or you put submission in on open space, you are still probably getting invites to these pre-hearing meetings at that level, because they're hoping to ensure that people have the opportunity of talking at that top level as well as when we get into the details of the rules. So since notification, what's Council been doing? Obviously, we know that the proposed Auckland Unitary Plan will be improved and enhanced through the submission process. That is the whole purpose of asking people to put in submissions. And so we have been obviously going through the submissions ourselves, but we've been doing some work to, in this particular issue, to focus on getting improved accuracy of mapping and background information. So far we've completed a review of over 2,300 of the sites on the sites of value overlay. And we've identified some of those that we will be indicating to the independent hearings panel that they need to be withdrawn from the overlay as a result of further research. We've been reviewing the submissions on the rules related to this part of the plan, and Council's position will go before the independent hearings panel. And lastly, we haven't put in place, in terms of people who are affected by this rule at the present time, a facilitation service to help applicants with the process, and we've also been liaising with mana whenua to get consistency and agreed understanding of processes. And just on the reason why these rules have effect at the moment, once again that goes back to the Resource Management Act. Before 2009, when a proposed plan was notified, all the rules in a proposed plan had effect from that point. In 2009, the government of the time changed that rule to say it's only matters of national importance that have effect at notification, and a few other rules. These rules fit under that matters of national importance, and that is why they have effect at this present time. And as I read out to you at the beginning, it's under Section 6 of the Act, which sets out the relationship of Māori to their lands, water, wahi tapu and other tanga is a matter of national importance in terms of the RMA. In terms of the facilitation service, so we've established and we are operating a process where we act as a facilitator with mana whenua to identify when a CIA is required. It's a no cost to the applicant to use this service. So if you are doing a resource consent which triggers a CIA requirement, if you go straight to the council, they will facilitate a discussion with mana whenua about whether or not a CIA is required. If you choose not to use that service, and we do know of some people who have chosen to go to a planning consultant who has not chosen to use that service and made themselves, the planning consultant has gone around and talked to the relevant mana whenua, then of course you will be charged the cost of the planning consultant. But if you go to the council service, you won't be charged that cost. And so through that, we have a team that are identifying which mana whenua you would need to contact. We contact those mana whenua. We give them a 15 working day time frame to come back to us and say yes or no, they don't need to be involved in the process. And then we give all of those responses to the applicant to understand the way forward. The responses that we get from mana whenua may relate to possible conditions of consent. They might want a site visit, or they might request a CIA. So far in the process to date, over the last 6 months, we have had 187 resource consents that have gone through the facilitation process. 28 of those were sites of value or sites of significance. 144 were for other CIAs that were triggered by resource consents, and the gentleman at the back talked about being in an outstanding natural landscape area. Outstanding natural landscapes, if you do any kind of building or activity in them, you are triggered a resource consent. One of the technical inputs you are required to provide, as well as landscape analysis, would be from mana whenua in that area. Only 12 of those have resulted in being a CIA being requested. So let's put that in a bit of context. In that same 6-month period, we had over 6,096 resource consents being processed by a resource consent team. Only 187 of them were to do with these mana whenua CIA provisions. The rest were for a range of other reasons. So just moving on to the CIA, what is it? It's a piece of technical information that is part of the resource consent. Just like we might require as part of a resource consent a traffic engineer's view on what are the traffic impacts of an activity, or an ecologist's view on the ecological impacts of an activity. All of those technical inputs are pulled together, and then the council planner, or it could be a planner, consultant planner, will balance up those inputs and make a recommendation. A CIA is not a veto given to mana whenua. It is an input. It is the council that makes a decision, not mana whenua. They have no decision-making rights in this process. So that's the end of that presentation. I just want to make one more comment. There was some comment about the transfer of power provisions in the Unitary Plan. So under the RMA, there are provisions that enable a local government to decide to do a co-governance arrangement with mana whenua, which enables the transfer of certain RMA powers to that mana whenua group. Currently in Auckland, we have no transfer of powers in operation. I will just explain. Can I just explain what's in the Unitary Plan? So what's in the Unitary Plan does indicate that the RMA does allow that to happen, and indicates that if Council will entertain looking at that concept for Māori land and for treaty settlement land. So in those circumstances where it's Māori land, transfer of powers would enable that mana whenua to do consenting on that piece of Māori land. Not consenting across the rest of Auckland. It would be very specific to their own land and to land that it's either ancestral land or treaty settlement land. For that to happen, that process would need to go through a committee of the governing body, and the governing body would need to make an agreement and a resolution that that's what they wanted to do. These transfer of powers are in operation in places like Taupō and have been in existence for some time in other parts of the country. It's not in existence at the moment. It is something that we're reflecting that we are able to do through the RMA, and it does not have any effect at the moment and wouldn't do so unless the council actually made a resolution to put one in place. So I'll just pass over to Roger.